And all of us should have been prepared for that. It is not acceptable that any council may suggest that when a date has been fixed for case management, especially in the circumstances of these proceedings where expedition is very paramount, to come to court and make an application that they should be given time to think about the issues. That is highly unacceptable.
Please, so, it was overtaken by events because there was an application which had to be determined. Yes.
No.
And
my lords.
We adjourned. The court adjourns a matter. We adjourned it to today for pretrial.
Yes.
Case management.
Yes.
Then an application was filed.
Yes.
And we thought that it was prudent on the part of the court to take the application, and we've taken it. So if we adjourn it tomorrow, we hope that you can do us a favor and file the issues. Yes.
Very well.
Because we don't want to impose the issues on you, but ultimately it's the court which will have to consider the issues which parties have filed, so that we proceed on the common
my lords, if we can take a cue from the precedent of the 2013 petition, this matter of issues to be tried was determined in open court. So it seems to me that if your lordships are directing that we come tomorrow for that, we should come and read out our issues and for the court to take up the issues.
Okay.
Because filing these matters may take some further time.
If you prepare in the morning, you cannot be at the registry. Sorry, file it at the registry. We are ready. In the morning.
Very well.
We are ready.
Unless we are just concerned that this matter be dealt with very expeditiously.
We are ready. We are ready.
My lords, I believe that I've indicated that it would not sacrifice expedition if we had until Thursday, because we also need access to a ruling that you've just delivered. Yeah.
Let the issues for determination be filed by tomorrow before 9:30 a.m. The case is adjourned to 9:30 tomorrow a.m.
My lords, just for clarification, I believe that beyond the determination of the issues, all other issues of case management will be dealt with tomorrow. Yes, yes.
rise.
All right, so the court has adjourned sitting till 9:30 tomorrow morning, and this followed the decision that was made after the application by the petitioner's lawyers for what they call interrogatory, the petitioners to ask the EC chairperson certain questions, especially regarding anomalies and subsequent corrections of the results as she declared on December 9. One of those issues had to do with the fact that the petitioners claim that at a point the results declared by the EC, when collated, would amount to more than 100%, indeed 100.3% is the figure they are talking about now. Edward Nyako, one of my colleagues in the Supreme Court, joins me right now. So let's summarize everything that happened today. So there was that application, really to what end?
Yeah, there were 12 questions that they sought to ask the EC. They go ahead. Apparently, in the week, could not be granted. And so the Supreme Court is now saying that they have to look at the case itself and which they term as case management as to the way forward. So the Chief Justice was asking the three counsels of the various petitioners, the petitioner, the EC, and then the Nanado side to sit together and think through what's next. In the wisdom of Mr. Chikata, he said that because the ruling has come in the way, he would have loved to have access to the ruling and go through it, and so he was suggesting that it should be Thursday. But Mr. Kutompa, on the side of the President and Akufo-Addo, was saying that they all came to court in the with the knowledge that they're going to proceed from start the case management and go ahead. So they are prepared, but the Chief Justice still insists that they have to go and sit down and then talk through, because he used the word want to be flexible. While they were saying that they need to deal with the matter expeditiously, he also said that yes, they want to deal with this expeditiously, but they need to be flexible and move ahead. So the decision is that they're going to give them access to the ruling.
And now we see some of the lawyers for the second respondents coming out at the moment. We see Mr. Frank Davis as well as
the court dismissed the petitioner's applications for interrogatives. You were not opposed to it, but you made comments regarding that. What are your response to the position now?
Well, thank you. Just to correct you, we were opposed to the application, but our opposition was on legal grounds because we hadn't filed an affidavit in opposition. So indeed, we were also opposed, much as first respondent was also opposed. Well, the real work in court has started. All this propaganda of having won 2 goals to 0. This is the first application that has formally been moved before the court. The application for a televised broadcast had already become moot because the court had already set in place the procedures for a live telecast. The application for interrogatories was dismissed outright by a unanimous panel of 7. This tells you that the petitioner has a long way to go insofar as this petition is concerned. There are ground rules which have been set for this petition, and the Supreme Court is not going to allow for unnecessary and interminable delays in the hearing of this petition. We are gladdened by the fact that the opposition remounted was exactly what was rendered by the Supreme Court in its ruling. We heard lawyer for petitioner talking about time to have certified true copy of the ruling. Well, that is his right, but that would not delay the trial. The courts have indicated quite clearly that tomorrow morning we are here for the 8:30 a.m. we will be here. Indeed, just to let you know that we were ready and prepared with our issues, because the last time the court directed that it was going to be a pre-trial. Every lawyer knows that when the case is adjourned for pre-trial or case management, you have to prepare your issues. And if you bring an application to court, you are dismissed. So there is no need to wait for that to happen. Much more so when you filed your application just about 2:40 p.m. yesterday. What did you expect? So yes, the application has been dismissed. Whatever they do afterwards is their own business. But yes, the real case in court has now started.
Is your contention that they are delaying the process? We heard your colleague make that point that he wanted to be dealt with.
Well, what else could be further from the truth? We came to court when on the 14th. If indeed you wanted an application to be heard from the 4th,